Okay, we got 4 orders from the judge. We also have 2 subpoenas from Lori's defense team here. This one is for Carrie Reed from the Lawrence Institute for Education, and they're asking for her to appear on February 2nd, 2023 as a witness, and they want any and all school records, including attendance records, disciplinary records, records of accomplishments, or any other records in your possession or control that may pertain to JJ with the date of birth May 25th, 2012. So I find that is interesting. And this one here, we've seen this one here before. They're asking for somebody from the church. Who is it? Dave Tanner from the LDS Church, also on that day, and what they want to know is any and all church records, including attendance records, temple records, disciplinary records, records of accomplishments, any other records in possession or control may pertain to Lori Vallow, aka Daybell, aka Cox, aka Brian, and they forgot another name, but I can't remember what that is. So that is interesting to me, and I'll tell you why here in a minute. Okay, you guys, do you remember this? Mr. Markey Means here, when he subpoenaed the LDS Church before, and what happened? Nothing. He didn't get his way, so he went on a, like a 17-page rant. And what ended up happening is, let's see, what do they say? Hold on, I'll find it. Give me a minute, guys. Okay, and this is what they got back from the church. Motion to squash or modify it. Okay, it says here the LDS and William Don Dowling in his personal capacity as the state president of the Hecksburg Henry Fork stake of LDS, by and through his counsel of record, Curtin McCorkey, respectively moved the court for an entry of an order modifying or squashing the subpoena served on them by Lori. See? It's going to happen again, you guys. See? That's from their attorney. And so they're trying it again. They're trying a Markey move. Okay, also, I will put the link to this change.org, and this is to allow cameras during court proceedings for the jury trial, so we can watch it. Because unfortunately, nobody can watch it as of right now, unless you're physically there in Idaho. Here is the amended notice of trial settings, pre-trial conference, and scheduling order governing further proceedings. Pre-trial conference will be 2/23/23 at 9 a.m. Jury trial is supposed to start on April 3rd, 2023 to 6/9/2023, which will be interesting because we're going to see what they're going to try to pull, especially Crybaby Johnny Boy. Okay, and here's that order of sequestering the jury, denied. And then defendant's motion to continue, denied. Oh, I bet you Donnie's really mad now. Madder than yesterday, or the day before, whatever day it was.
That I be provided some DNA evidence. I do not have that evidence. And I could really care less whether the state thinks it's exculpatory or not. It doesn't matter what they think, and I could care less what they think. But I'm concerned about what I think. And if I think that evidence is exculpatory, I'm entitled to it. And I'm entitled not only to have that evidence, I'm entitled to test that evidence and have an adequate amount of time to do so. And they don't get to dictate and one-sided, and we've been through this before, and I didn't want to turn into this kind of a tone, Judge, but we've been down this road before. They don't get to dictate what's exculpatory and what I want to use in my case.
No, they don't.
The only thing they're entitled to is I'm going to show them what evidence I'm going to use. That's what they're entitled to, and they're going to get that. But until they get those reports and the expert reports that I have to prepare, I want the evidence. I want the evidence. I want my expert to have an adequate amount of time to test it, and Ms. Blake brought this up. In both of those DNA cases, Judge, I entered into a stipulation that allowed their expert to test the evidence, give me the report 20 days ago, 3 weeks ago. And we entered into, again, a stipulation in an order that allows them to test it, and on their schedule, get me the report so that I can follow up and do my own testing, and then get a report.
He's mad.
And I don't care what they say. I'm entitled to all evidence and make my own adequate determination as to whether it's exculpatory or not.
No,
and they can't tell me when I'm going to get the evidence. And I'm not going to sit here and say, well, you got me the evidence and you decided that it wasn't important enough. That's not the way this works. I want the evidence. I want time to be able to test it. I want time to be able to issue a report. And I want time to be able to prepare for trial. And you're asking me to do that in the next 9.5 weeks, and they haven't even got me the evidence yet.
That's right.
And I disagree wholeheartedly with Ms. Blake.
Go, Johnny boy. Go.
Quite frankly, you don't get me the evidence.
That's right.
And I don't do a good job. And I have to hold...